No, I don't want to.
See,
They were singing about I was in it last night. Yeah, because you guys are like turning your question.
Good morning.
Good morning.
Good morning. So I want to begin with a couple of things. First of all, I want to begin by turning this camera is looking a little bit more at me for the benefit of our recording. That looks about right. A couple of things that I want to mention with respect to Tuesday. First of all, I want to apologize for holding you guys over. You can ask folks who took classes with me last semester. That is not a habit that I get into. And to be perfectly frank, the only explanation that I have is 11:10 to 12:05 is a little bit weird. And so my brain did not compute that correctly. So we're gonna keep a closer eye on the clock and make sure that we call it a day at 12:05. The other thing that I wanted to flag for you guys was I wanted to point out something that happened to a couple of you during our dialogue Tuesday, which was you were giving me answers that were correct statements of law that were irrelevant to the facts that you were being given. And this happened to several folks. And I want to flag this early because I think this is a thing that law students run into, which is you get really, and this happened to me when I was a law student, so don't feel like I'm picking on you, right? I'm telling you what happened to me. You get really excited about showing off what you know, what you have gleaned from the readings and from your own thinking. And you forget that the practice of law is as much about discarding things that don't matter as it is about correctly analyzing particular issues of law. And so I really want to encourage you when we are working through these hypotheticals and fact patterns as we continue on over the course of the semester, read them closely and make sure that the answers that you're coming up with, that you are discerning, are relevant to the hypothetical that you're being asked to answer. So, for example, if the question asks you, can you bring this state law claim in federal court? Do we care about arising under jurisdiction? This is a yes or no. Give me the north-south nod or the east-west nod. Do we care? No, we do not. We have been told this is a state law claim. And so arising under jurisdiction requires there to be a question of federal law. Without a question of federal law, arising under jurisdiction ceases to matter. Okay? This is important. Okay, this is important for our discussion on supplemental jurisdiction because 1367 expresses a difference in how it operates between arising under jurisdiction and diversity jurisdiction. If your original jurisdiction claim, if your ice cream cone, your Christmas tree, if that is an arising under jurisdictional claim, if it comes from 1331, if it's a federal question, then supplemental jurisdiction comes along behind, and you can put any state law claim you want attached to that, as long as you meet the common nucleus of operative fact standard, right? If your ice cream cone is a diversity jurisdiction claim, then you have to investigate whether 1367B operates to remove supplemental jurisdiction. Okay? What questions do we have so far? Nothing? Okay. Then let me, oh wait, no, they fixed the classroom clicker. Okay. So today, most of what we are going to be doing is attempting to examine the contours of 1367B. Okay, but not entirely. We're going to finish by wrapping up with a couple of more conceptual ideas. So here is my first question, and we're going to give this to Ms. Stewart. Ms. Stewart, I would like you to pull up the statutory text and find where this language from Gibbs is reflected in the statute. What is the statutory text that the court is implicitly relying on in order to get here?
They're relying on 1367 C4, which is in exceptional circumstances, there are other compelling reasons for declining jurisdiction.
That is correct. So it's even a little broader than that. 1367C in general grants district courts discretion to decline to exercise supplemental jurisdiction. So even if 1367A has operated, and even if 1367B does not operate for any of the many reasons that it does not operate, 1367C can operate so that the district court says, you know what, we're not going to hear this claim. let me tell you a story about a 1367C case from my own time in practice. So this will just take us a minute. So I was a labor and employment lawyer, in particular a wage and hour lawyer, mostly plaintiff side, but I also represented small businesses on the defense side. And there was another firm in the community where I practiced who was notorious for being only wage and hour, only plaintiff side, and taking any damn case that walked through the door to try and extort settlements out of defendants. And if you're wondering why that's a viable business model, it's because wage and hour law is probably the most plaintiff-friendly realm of employment law that remains in the United States. For the most part, defendants in wage and hour cases are being advised on risk management, not on whether they're liable, right? So it's a question of how much you're gonna pay, not are you gonna pay. So this is a viable business model. This other firm, whom frankly I regarded as somewhat unscrupulous, you may have gathered that from my use of the word extort in describing their business model. They sued a small restaurant. And part of the allegations of the lawsuit was that the restaurant had failed to keep appropriate records of hours worked and wages paid, which is required by the statute. So they hired me and my business partner to represent. The restaurant hired us. And in our investigation, we discovered that the reason the restaurant didn't have any records of wages and hours is because the named plaintiff who had hired this firm was the manager who was responsible for keeping the records up to date. And she had stolen all of them. So we file a counterclaim. We say, hey, we have this claim for conversion, right? You've stolen all of our records. You've stolen money out of the cash register. We'd like to get all of that back. District judge dismissed the counterclaim. Said, yes, we have a common nucleus of operative fact because this term, whether you are, your liability and the burden of proof that you have under the wage and hour claim is intimately connected to the proof that you'll put on of the counterclaim. But wage claims should be about wages. We should not get bogged down in litigating ancillary issues. And so I am exercising my discretion under 1367C to dismiss this counterclaim that I have jurisdiction to hear, and that is not precluded by 1367B, but I am choosing not to hear it. So 1367C is essentially I do what I want for federal judges. They run with 12 gangs. That might be a little old as a cultural reference for you guys, but absolutely right. Even with 1367A and even without 1367B, your state law claim may still get tossed as a discretionary act. Okay? So let's wrap up before we move on to joinder issues. And Mr. Booth, what three things are necessary for supplemental jurisdiction to operate?
The claim where federally you wouldn't normally have jurisdictions is the claim.
Okay.
You need a lawsuit that consists of more than one claim. State and federal claim.
Okay.
You need the federal claim to the federal court rather have valid jurisdiction over at least one of those claims. through diversity or federal question. And you need the multiple cases to arise at the same common nucleus father.
How many things is that?
It's roughly 3 if you combine a couple.
How can we combine them to get to 3?
You need 2 cases, they need to be related, and one of them has to be federal.
Good enough. Here is the answer that the phrasing that I came up with. I don't dislike Mr. Booth's phrasing, but just to give you sort of the right answer for whatever that's worth. You need a claim within the original jurisdiction of the federal court, a state law claim that is not within the original jurisdiction of the federal court, right? Because if that second claim, if you have diversity, you don't need supplemental jurisdiction for that second claim, right? And finally, a relationship between the federal claim and the state claim such that both claims derive from a common nucleus of operative fact. Okay. So now we are going to be playing with some hypotheticals for a while. For all of these hypotheticals, please assume that 1367C does not apply. So if supplemental jurisdiction exists, we do not have to inquire into whether the discretion of the court justifies laying them aside. If supplemental jurisdiction exists, we move forward. So, Mr. Harrison, Robert sues Glenn for violation of a federal statute. Robert is a citizen of Alabama, roll tide, and Glenn is a citizen of Ohio. As per Rule 14, Glenn impleads Susan, a citizen of Alabama, on a state law contribution claim. Is there supplemental jurisdiction for Glenn's claim against Susan? Now, here is a free diagram to help you make sense of how these claims are put together. I have been doing this long enough that I can evaluate these kinds of problems without a diagram. You will get there too. You are not there yet. I would encourage you to draw one of these each and every time you come up with one of these problems. They don't have to be elaborate, right? This is not elaborate. You don't even have to draw shapes if you're not artistically inclined, but give yourself a visual of the relationships between the parties and the claims. So, Mr. Harrison, is there supplemental jurisdiction for Glenn's claim against Susan?
Yes, because claim is joined under 14A2C. So it's related to the initial claim Robert has against Glenn. So it will form part of the common operating nucleus.
Okay. So 1367A operates. All right. Mr. Simmons, does 1367B operate?
I said no because there's already original federal jurisdiction on the claim.
What kind of original federal jurisdiction? I mean, you're right, but the problem is that original federal jurisdiction doesn't explain why you're right. Because there are 2 kinds of original federal jurisdiction, right?
Diversity and non-controversy.
Diversity and arising under, right? And under which one of those 2 are you correct?
Diversity.
Somebody want to help him? You had a 50-50 chance. So, right, remember, if your ice cream cone is a federal question claim, 1367B does not operate. You just lay it aside. Okay. So, Mr. Harrison, I'm going to come back to you. You said that there is a common nucleus of operative fact between these two claims. That's a correct statement of the standard. Can you explain for us why you think there is a common nucleus of operative fact here?
Susan's claim is being joined, or it's being asserted against it's a defense against the plaintiff. So she's the third party defendant asserting a defense against the plaintiff for, I guess, for the same claim that
You're right. You're right. I can see you like you're struggling for the words, and I understand, but you're right. Okay. So think back to your torts class. Contribution is a mechanism whereby defendant A says, look, maybe I'm liable, maybe I'm not. But to the extent that I'm liable, it's because defendant B is responsible for my actions. And so they should have to reimburse me for anything I pay you. And of course, since that makes me just a pass-through, I get to step out of the transaction altogether, right? And B pays the plaintiff. So if the claim is that Glenn violated some federal statute, but he did so because Susan forced him to, don't think too hard about it, all right? But like if that's how it happened, then yeah, we have a common nucleus of operative fact, okay? All right. Next. So questions about this problem? No? Okay. Next, same facts as before, but now we also have a state law claim from Susan against Robert, also under 14A2C. So, Ms. Morgan, come on down. Draw us your diagram, please. Well, if it helps, right? So
Right.
it starts the same as this one. I think that black marker is a little better. And you don't have to fully write out the claims, just mark the basis of jurisdiction.
So she's asserting Lynn against Robert.
Why is Susan in this case at all?
Because Glenn brought her in,
So shouldn't you mark that claim as well?
probably.
Yep. Okay. So Robert's claim against Glenn is on what basis of jurisdiction? Look here. It's right here.
A federal statute, so original.
Right. So mark it. Okay. And Glenn's claim against Susan is what basis?
Supplemental.
Right. All right. So, and what kind of claim is Susan asserting? Now you got to look at the question.
Yeah. A state law.
Right. So mark that. Okay, so this is good. This is correct. All right, you are released.
Thank you, everybody.
Round of applause. All right, great job. Great job, Ms. Morgan. All right, so on this basis, okay, Ms. Feldkamp, is there supplemental jurisdiction for Susan's claim against Robert?
No,
Okay, why not?
because it's for stable,
I'm sorry?
because it's for stable.
Well, supplemental jurisdiction only operates for state law claims.
Okay, so then, yes, because it's state law.
All right, let's take it back, okay? So we are assuming that the joinder rules do not preclude this. Okay, that rule 14 does not preclude this. What does Ms. Feldkamp, what does rule 14A2C state is the standard for joinder of claims?
Party may assert against the plaintiff any defense that the third party plaintiff has to the plaintiff's claim.
Say it again.
It says it may assert against the plaintiff any defense that the third party plaintiff has to the plaintiff's claim.
That is that 14A2C?
Yeah.
Give me the rule book. Good. Things may have gotten reordered in the new edition.
Okay.
So let's see. 14A. Okay, 14A2D. Give us the standard for 14A2D.
Okay, may also assert against the plaintiff any claim arising out of the transaction or occurrence that is the subject matter of the plaintiff's claim against the third party plaintiff.
That's the one. Okay. We'll blame the committee on that one. So the Susan's claim, because it meets the 14A2D standard, it arises out of the transaction or occurrence that is the subject matter of Robert's claim against Glenn. Does that mean there is a common nucleus of operative fact, Ms. Feldkamp?
Yes.
It must. It has to, right? Because it's the same transaction and occurrence. So clearly there's the same, there's common facts here. Okay? So does that meet the 1367A standard?
Yes.
Okay. However, oh, I'm sorry, I was looking at the wrong page of my notes. Okay, so because of this, what's, as Ms. Morgan gave us, the OG jurisdiction, what's the source of OG jurisdiction, Ms. Duncan?
The federal.
Right? And so does 1367B operate? You're shaking your head.
No.
Right. Okay. So this claim is allowed. Questions about this problem so far, right? 13 and 14, very similar, right? The point being, supplemental jurisdiction, as long as you've got that original, that 1331 jurisdiction, supplemental jurisdiction can reach as far around the chain of claims as it needs to. Okay. So any questions? Yes.
So on the state law claim, if the rule doesn't apply, you just look at the claim to see if it's related to the case and controversy, or
What do you mean by the rule doesn't apply?
like here it says rule D, part D on it. So you already know it's part of the same case and controversy But if that rule doesn't apply and some other rule applies, you just look at the claim to see if it's part of the same case of controversy.
I mean, so what I would say is that in general, if you are dealing with a joinder of claims issue, you have already cleared the 1367A hurdle. Think back to our Venn diagram from Tuesday. Okay. Joinder of claims requires that the claims be connected through the same transaction or occurrence. Whether you're dealing with Rule 13, Rule 14, or Rule 20, they're all looking at the same transaction and occurrence, or the same series of transactions and occurrence, which is a narrower standard than the common nucleus of operative fact. If you're dealing with joinder of parties, so that's Rule 18, Rule 19, Rule 20, Rule 24, then you may have to ask, okay, what's going on with these claims? Are they talking about the same events, right? That kind of thing. So there's a distinction here between joinder of claims and joinder of parties. Incidentally, here is a bar exam tip. When I took the bar exam, years ago, there was an MEE question that was live, that was in circulation, that was being used on active MEEs, where the fact pattern was all about, oh, it's been 15 years now, so I'm trying to remember. I'm going to phrase this as an either or, because I honestly can't remember which it was. Either the fact pattern talked about relationships between claims, and then the call of the question asked about joinder of parties, or the fact pattern talked about joinder of parties, and then the call of the question asked about joinder of claims. And you could get full credit by pointing out that the call of the question was wrong. Now, you also got full credit, and you could actually get a little bit of extra credit to make up lost points elsewhere by pointing out the call of the question was wrong and answering it anyway, or answering what the question was actually asking. So if the call of the question asks for joinder of parties, you say joinder of parties is irrelevant because this is the fact pattern presents a joinder of claims issue, and here's how you analyze the joinder of claims issue, right? Or vice versa. Okay. Any more questions about this problem before we move on? Okay, so as we can see, right, Ms. Morgan's given us an excellent diagram. Moving on. Still looking at the same facts, but we assume that the jurisdiction for Robert's claim against Glenn is based solely on diversity of citizenship and not on a federal statute. So Mr. Cruz, is there supplemental jurisdiction for Glenn's claim against Susan? Why don't you start coming down and altering this diagram to reflect what we need for this problem?
I have to pass on that one. I was still adding the notes from the previous question. So was it?
Well, it's right here. You're sure? Are you? If you want to pass, you can pass, but I want to give you that opportunity because the question's right here. If you want to take a look at it.
I'll go ahead.
Okay. All right. Then, Mr. Falk,
Yes.
please alter the chart.
assume jurisdiction. So then we're gonna not have jurisdiction. Emergency jurisdiction, which means that we cannot have specifically supplemental jurisdiction.
Well, it means that we have to inquire
Right.
whether you are correct, right? So 1367A. So this is correct. So you're excused. Round of applause from Mr. Kellogg. All right. So, well, the other thing. So, Susan's counterclaim also ceases to exist, right? So we're back in the original problem without Susan's claim. Okay. So, Ms. Sadler, is there supplemental jurisdiction for Glenn's claim against Susan?
I said yes, because Glenn's the defendant, and under 1367B, it bars plaintiffs from supplemental jurisdiction when adding third parties.
Exactly right. Okay, so let me expand on this a little bit. For those of you who maybe did not follow all of the implicit reasoning, okay? 1367A requires original jurisdiction claim, diversity, state law claim without original jurisdiction. So Susan's citizenship destroys diversity, so there's no longer original jurisdiction for the claim against her. And common nucleus of operative fact. So again, contribution by definition has common nucleus of operative fact. So 1367A operates. Ms. Sadler is correct that you then have to ask about 1367B because the original jurisdiction claim is based solely on diversity of citizenship. But Ms. Sadler is also correct that 1367B does not operate here because, as she points out, 1367B excludes claims by plaintiffs against persons made parties under Rule 14, and Glenn's claim is a claim by a defendant against a person made a party under Rule 14. Questions about this?
So on our diagram, we have an arrow from Glenn down to Susan because of what?
Because he's presenting a claim.
Right, like on this.
Yeah. So
Draw an arrow.
Yep.
Because of Rule 14 and not because of.
Yep. So Rule 14 is what brings Susan in, but then we are asking, does the court have the jurisdiction to hear the claim? Okay. Any other questions?
So do they have supplemental jurisdiction, or is it they're in there because of Rule 14?
Okay. This is important. Okay, and this is actually helpful. The diagram is intended to help you see the relationships so that you can determine whether supplemental jurisdiction exists. The diagram does not state whether there's jurisdiction over a particular claim. It's intended to help you see the relationships. Okay. And I think the next problem not the next problem, but the one after will help make this clear. So just to be clear and sort of lay the question to rest, Ms. Sadler, is there supplemental jurisdiction?
Yes,
Why?
because Glenn is adding Susan.
Right. If Robert was adding Susan, we would be in a different ballgame. Okay? Because then that would be a claim by a plaintiff against a person made party under Rule 14. Okay. Any other questions? All right. Next question. Still dealing with Robert, Glenn, and Susan. We are now adding a state law claim by Susan against Robert as permitted by 14A2D. So Ms. Gleason, if you'd be so kind as to alter our diagram.
So the black marker works best.
I mean, you can see.
Yep. Yep.
Well,
This is for 16. Yep.
Yeah.
So when we look at this, we can say yes.
well, let me pause you right here.
You want me to?
Do we feel okay with this chart? We're seeing some shakes. Why do we not like this chart?
Robert can't sue Susan.
So the way that we've done the chart up to this point, the arrows point at the defendants. So you're showing that Robert is suing Susan. Is that
Isn't that what the problem said?
what does the problem say?
So supplemental jurisdiction by Susan against Robert. Sorry.
Exactly right. Okay, you're released.
Sorry.
So we can see this here. Right? So Mr. Hoover, do you think that there is supplemental jurisdiction for Susan's claim?
I would say so.
Okay,
The way I walk through it is the federal court has original jurisdiction based on diversity. Susan's claim against the plaintiff would be proper because under section 1367B, it's not applicable as Susan's the defendant. It's going against the plaintiff rather than vice versa.
again, right? You have our fancy pants chart. Plaintiffs against persons made parties, and this is person made a party against the plaintiff. So this, I think, is an important distinction. Because Robert is the defendant in this claim, there is supplemental jurisdiction. As we said before, Robert suing Susan does not present supplemental jurisdiction. Why? Because 1367B operates. Okay. Questions about this? Okay. So now we have, ta-da! So, Ms. Gleason, I'm going to pick on you again.
You should.
Can you come and fix the chart again?
Look at mine.
I've done that so many times. Do not feel bad.
Yeah.
Do not feel bad in the slightest. Yes. Round of applause for Ms. Gleason. All right. So Mr. Adams. Is there supplemental jurisdiction over this claim?
Yes,
Okay, why?
because we have the diversity jurisdiction with Glenn, and then he's asserting a state claim against Susan, which would fulfill the two parts, and we assume it's of the same operative fact, otherwise he legally couldn't bring it. Likely.
Do we agree?
Um,
Mr. Gonzalez, you're shaking your head. Why do you disagree?
I disagree because under rule 1367B.
It's not a rule, it's a statute.
Sorry, statute. 28 USC 1367B, it prevents the plaintiff from bringing claims against parties made, individuals made parties under Rule 14.
Right. And is Robert a plaintiff?
Yeah.
Is Susan a person made a party under Rule 14?
Yes.
And so 1367B operates to deprive the court of supplemental jurisdiction. You guys have been doing this, handling this pretty well. So we're going to take a little bit of a tangent into a complication. Here is the complication. This is your reward for being smart. So, when you look at 1367B more closely, what you find is that it operates to deprive supplemental jurisdiction in cases like this one, when exercising supplemental jurisdiction over such claims would be inconsistent with the jurisdictional requirements of Section 1332. So I'll throw this out to all of you, and if we're all stumped, I'll just give you the answer. Maybe I shouldn't say that, because then that incentivizes everybody to shut up. But that's how we'll play it. What does it mean to be inconsistent with the jurisdictional requirements of Section 1332? Yes.
If it's inconsistent with section 1332, then they aren't meeting 1332. So.
Well, specifically, it's inconsistent. It's where exercising supplemental jurisdiction would be inconsistent with the jurisdictional requirements of Section
Right. So
1332.
if they exercise supplemental jurisdiction, they're making them 1332.
So who made it inconsistent?
Robert by doing Susan, because then there wouldn't be complete jurisdiction.
But did Robert sue Susan first?
Not first, but if he does, then there's not.
So who killed diversity?
I guess Glenn would have by
Glenn did, right? By bringing Susan in. So there are some courts, not all, but some, that will say that Robert is not responsible for the destruction of diversity of citizenship. And so, exercising supplemental jurisdiction over his claim is not inconsistent with the requirements of 1332. That what would be inconsistent with the requirements of 1332, according to these courts, would be if Robert had dragged Susan into the case through Rule 14 and then asserted a claim against her. Or, maybe a little less persuasively, if Glenn had dragged Susan in through Rule 14 through his contribution claim, and then Robert goes, oh, hey, Susan's in this case now. I can assert my claim against her without her ever bringing a claim against him. Okay.
So just to clarify that, then the order is important. The order in which the claims are filed is important.
In these courts that use this logic, yes, the order does matter. In that, if there's evidence, right, and the evidence can be as simple as Robert didn't move first. If there's evidence that Robert wasn't going to go after Susan until she went after him, then the plaintiff is not acting inconsistent with the requirements of 1332. Okay. All of this is to say that supplemental jurisdiction, like, does this feel complicated to you guys? A little bit. Some folks are saying no. There are wrinkles here, but they're predictable. Okay. And I think that is a fair way to describe civil procedure generally. This is complicated. You need to sit down and think through the steps. But thinking through the steps is rewarded with predictable answers. Which, look, I'm going to be straight with you guys. Anything in the law that involves a reasonableness standard, you can think about it as much as you want, and if you come up with predictable answers, good job. Congratulations, the judges are just like you. But in civil procedure, thinking through the steps is rewarded because you will always get the same answer if you think through the steps in the same way. Okay. Last thing that we're going to do today. So we're assuming the same orientation of the parties and bases of jurisdiction as in question 17. But now, Robert's claim against Susan is based on Susan's violation of a federal statute. So, Ms. Brand, would there be supplemental jurisdiction over Robert's claim against Susan?
From my understanding, it's no.
Why not?
Because Robert cannot sue Susan because he didn't add her to the party.
Okay. Mr. Thompson, would there be supplemental jurisdiction over Robert's claim against Susan?
I said yes, because Robert's claim against Susan is a federal question, so it establishes original jurisdiction.
And so is there supplemental jurisdiction?
It doesn't matter. It's irrelevant because you can sue it directly, so we don't need some jurisdiction.
So the answer to the question as posed is no, but it is because our friend who is not on my seating chart.
I missed.
It's not a big deal. I went to look up your name and went, oh, you don't exist on my chart. It's fine. But as our new friend pointed out, there's original jurisdiction. So it doesn't matter if there's supplemental jurisdiction. Okay. So if one second, right? If you see this question on an exam, whether it's my exam or the bar exam, what's the answer? No, because original jurisdiction exists and you don't need supplemental jurisdiction. Mr. Paul, you had a question?
So if Robert wants to sue Susan, but he knows that federal courts are going to be more preferable, then he would sue Glenn so he can get diversity jurisdiction, so he can get it in federal court. Glenn then sues Susan.
If are you talking about in this fact pattern?
Yes.
In this fact pattern?
No, in the diversity one from before.
Okay.
I'm just wrapping my head around how this system is used to get around a state court to get to federal court.
Well, we're actually going to talk about that in a couple of weeks. Okay, so we are almost out of time, so let me just hit a couple of administrative things to wrap up. The first one is I'm keeping an eye on how fast we're progressing because on Tuesday we got through the entire quota of DRQs in about half the class, and today we got through 8 of the 10. So we're keeping an eye on that. You may get an increase in quota in the next couple of weeks, but you will hear from me in writing about that. Second, when you finish a chapter, if you haven't finished your quota for the day, go on to the next chapter. The third administrative thing is go on to the next chapter, except when the next chapter is the class actions chapter. So we're doing supplemental now. Next chapter is removal, and then you get to class actions. Just skip class actions. We're going to go right on into Erie. Yes, Mr. Hoover.
Chris, I didn't know today for attendance if we were doing it.
I looked at, I don't know if you noticed because it was up on the screen. I was playing with D2L and I couldn't get the code for you guys. So no attendance taken today. Do not worry about it. We'll see you guys on Tuesday. So, because I clearly have done something wrong with the attendance taken. So, all right. Take care, guys. We'll see you on Tuesday. Hello. Hello.